Senator Paterson.
Madam Deputy President, I present the report of the Parliamentary Joint Committee on Human Rights on Freedom of Speech in Australia, together with the Hansard record of proceedings and documents presented to the committee, and move that the report be printed.
Is that motion as put by Senator Paterson agreed to? Those of that opinion say aye. Against? Declare that carried.
I move that the Senate take note of the report. Thank you, Madam Deputy President. I want to begin tonight by talking about the committee process and obviously the committee report. But fortuitously, we've had the announcement of the government's response to the report today, so I'm also going to address that in my remarks. Firstly, I want to place on the record my appreciation and thanks to the Secretariat of the committee, who did heroic work in short time to assist the committee with its work, receiving over 10,000 submissions, holding over 9 hearings in 6 cities. It was a phenomenal effort, and I know all members of the committee are very grateful for the support that we received from the Secretariat. I'm also very grateful to my colleagues on the committee, both my coalition colleagues and colleagues from other parties, for the way in which they participated in this inquiry. It was a genuine inquiry of people with sincere beliefs, and different conclusions were drawn, obviously. But everyone brought to this debate their own values and their own principles. And I recognise the sincere commitment that my colleagues have to these issues. Ultimately, as a committee, we were wrestling with, on the one hand, a very fundamental freedom which I think we should all cherish and which is so central to living in a free society, living in a liberal democracy, and that's freedom of speech. And on the other hand, the right not to be discriminated against, and for me particularly, the right to feel safe and included in the Australian community. And they are difficult issues to reconcile. They do clash, and ultimately this is a question about where we draw the line. I believe the committee report pointed in a good direction and gave the government a good path, which they've now taken up to resolve that issue. And I think the government has done so today with a reasonable compromise. I say compromise because one of the things I think all members of the committee agreed to during this process is that the Queensland University of Technology students' case was a travesty of justice and should never happen again. But we had different views on the committee about how best to ensure that a case like that never happened again. There are those that believe, and by the comments today I assume that includes members of the Labor Party and the Greens, that it would be sufficient only to update the Human Rights Commission's processes to ensure that a QUT case doesn't happen again. And even though I very much welcome the proposed changes to the Human Rights Commission's processes announced by the government today, I don't think that they are sufficient on their own to ensure that we never have another QUT case again. And I want to use this opportunity to outline in detail why I think that is. The first thing is that the Human Rights Commission already has the power to terminate unmeritorious, vexatious, weak cases. And in this case, they didn't use those existing powers. The President of the Human Rights Commission has said publicly that she believed that this case had a level of merit, and that's why it was not terminated. So I'm not confident that extra powers to terminate cases like this would ensure that this case would have been terminated. But even if they did provide that a QUT case in the future would be terminated by the Commission, I'm not convinced that that would have been sufficient to discourage what we had in this case, which is a very determined applicant and lawyers who advised her to continue this case. Not only did this applicant continue it beyond conciliation when conciliation was unsuccessful and take it to the Federal Circuit Court, but when she was unsuccessful in the Federal Circuit Court and when costs were awarded against her in the Federal Circuit Court, she chose to appeal the court's decision to the federal court and continue the case. Clearly, any discouragement that was put in place at the Human Rights Commission level by these reforms to the Human Rights Commission processes would not have been sufficient to dissuade the applicant in this case. But I'm also concerned not just about the 3 students who ultimately went to court and defended themselves, though I have great admiration for them and their lawyers who offered their services pro bono to defend this case, this important principal case. I'm also concerned about the 3 students who elected to reach a confidential financial settlement with the applicant. They did so for a number of reasons. One is they didn't want to be accused in public of being racist and having breached the Racial Discrimination Act, and I don't blame them for not wanting that on their record. The students who persisted with the case have detailed to the committee how this profoundly affected their lives and careers. But the other reason that they did so is because they didn't have confidence that, had it gone to court, that they would have been successful in defending their case. And so they elected to pay money, and it's been reported that it was $5,000 each, and it was also reported that they offered to settle for lesser amounts or to apologise, but the applicant in this case did not accept those offers. And so those students felt that the law was so stacked against them that there was no choice but to pay money that some of them have testified they could barely afford and had to really scrounge together to afford. They chose to do that because the law was so stacked against them. And that is why change to the law itself is also necessary. I'm very pleased today that the Prime Minister and the Attorney-General have announced that the government intends to reform 18C by removing the words offend, insult and humiliate and adding the word harassment in its place, keeping the word intimidate in the law. That will give future students, like those at QUT, confidence that if they are accused of this and if the Human Rights Commission handles it well or badly, that ultimately if they choose to defend their case in court, that they will get a fair hearing, that there's a good chance that they will get off. And hopefully it won't take them 3.5 years to clear their name, as it did for the students who did decide to defend their name in this case. The government will also proceed to reforming the test in 18C to ensure that it is an actual objective community standards test. A number of court cases have narrowed this reasonable person test to make it, not just in my view, a relatively subjective test, but in the view of many legal experts like Professor George Williams and Justice Sackville, that it is a relatively subjective test because it relies on the perception of offence, insult or humiliation under the current law of a member of the affected community rather than a member of the Australian community at large. So I think that's an important and welcome reform. Going forward, the challenge is now before the Parliament. The government has resolved its position and is moving forward on this, and it's now up to the Parliament to decide what, if any, reforms it is willing to vote for. I hope they don't just vote. I hope that we don't just vote for Human Rights Commission changes alone, because as I've said, I don't think that will ensure there are no more QUTs or indeed no more Bill Leak cases. I hope they also vote to change the law. And I hope that in doing so, in considering how they do that, members of this place consider that if these reforms are defeated, and if there is another case like QUT, that will be on their conscience. It will be their fault because they've decided to oppose reasonable compromise reforms. The only thing we can do to guarantee that there'll be no more QUT cases or Bill Leak cases or Andrew Bolt cases is to repeal 18C entirely. And that's not something that has support of this Parliament and is clearly not going to happen. But we can substantially reduce the risks that will happen. And we can do that by voting for both of these reforms. If we don't do that, we're running the very real risk that one of the 76 cases that are before the Human Rights Commission today on 18C, or any of those that might be brought in the future, will turn into the next Bill Leak or the next QUT. And two things will happen. One, people who voted in this place not to reform this law will have to take responsibility for those cases. And two, you can expect the Australian public to be even less sympathetic to the law or the Human Rights Commission than they are today. If they see again this law being misused to pursue students, cartoonists or journalists, I suspect they'll be much less sympathetic to arguments to retain these laws and might even be more sympathetic to going further and getting rid of all these laws together. So if you want to preserve 18C in some form, if you want to preserve a targeted limitation on racial abuse, which I think we should have in this country, then the time is now to vote for the reform that is on the table, because it will ensure that harassment and intimidation based on race are unlawful, as they should be, and it will ensure that freedom of speech is better protected. This is about finding a better balance. I'm very pleased that the government has so carefully studied the report of this committee and has taken up many of the recommendations in the committee, and I'm very hopeful that the Parliament will give it equal consideration and ultimately support it.
Thank you, Senator.